As noted by Byron yesterday, our contract with the Vince expires, runs out at the end of next year. We're exploring new opportunities. I know this is a great venue. People like it. If there's other areas in the state that you would like for us to consider, please let us know. This is your contract. We do this for you. And so we're open to suggestions. Otherwise, have a great morning.
David, what are the dates for next year?
That's a great question. I'll get great question. I'll get back to you with that at the next break.
Okay, thank you.
Otherwise, enjoy.
All right, good morning, everyone. My name is Lindsey Simon, and I am a professor at the University of the School of Law in Athens here. And we're here this morning to discuss bankruptcy in the headlines. Before we begin, I'd like to introduce the other panelists, which really, they don't need an introduction, but I will do so anyway. First, we have Judge Grace Diehl, who retired, but as Judge Bonner said, maybe not quite so retired. So glad to have her here on this panel. And then also, we have Dennis Connolly from Alston & Bird LLP in Atlanta, Georgia. So today, as I said, we're discussing bankruptcy in the headlines. The focus of our panel is over the last year, bankruptcy issues that made the news. Now, for many people who, they're a bankruptcy practitioner in their family, when you come to the holidays and you sit around the table, people see what's in the news in bankruptcy and they may ask you about that. That's much of what the general public knows about the bankruptcy process. And so starting from that place and looking at instances where bankruptcy made the news this year, the purpose of this panel is to categorize and group those big headlines into information that may be useful for you all, both in your practice and then just your general understanding of where the practice of bankruptcy is headed. So just a basic background of what we're doing. We have 4 broad topics we're going to address during this panel, and as you see, they're very different. So our first is bankruptcy in distressed industries. Our second is bankruptcy in social movements. Third is bankruptcy in Congress, and then finally bankruptcy in emerging technology. Now, our goal is to invite conversation and question from the audience after each of these sections, because in our experience, in many panels, if you wait to the very end, you may have forgotten your question, you may not want to raise it, or there may not be enough time. So we've tried to avoid that today by, after each section, we're going to present some information and have an initial discussion, and then we'd like to open it up for questions after each section. So we thank all of you. We look forward to sharing this information and hearing your thoughts as well. All right, is this on? Perfect. I'm going to sit down for the rest of this. Hopefully you all can still hear me and hear all of us. We are going to begin with bankruptcy and distressed industries, and with this I'm going to pass it over to Dennis, who's going to lead us through.
Sure. Good morning, everyone. We were thinking about 3 separate subjects here indicated on the slide. We've got retail, which everyone obviously has seen across the country and in various retail iterations, and we'll talk about that. Trade wars and tariffs, which is the most current, one of the more current political scrums that we see in Washington, and how the tariff issue, both actual tariffs and perceived or potential tariffs, are affecting the economy and affecting segments of the economy. And then finally, another hot area that I've been involved in a lot, and I think a number of you have as well, healthcare unraveled, and this is an ongoing, it's a system that is Rube Goldberg-like in the way payments are made, and we were talking about the divorcing of the service versus the payment system, and the distortive effects of that. And so healthcare is an ongoing area as well. So with that, we'll dive in, and then Lynn's got the retail demise, and these are some of the famous names. Some of these one would never have expected. Sears was sort of the big catalog, and from nothing to the major entity back in the late 1800s. Long story short, no retailer is safe, and you see major retailers, Toys R Us is another one, but it really goes from large to small, and you see some niche players, I'll call them niche players, some very segmented market players like Dollar General do well, and then you see others not doing quite as well. And then you have this whole debate about Amazon and obviously all those other pressures on the industry. With respect to the retail demise, we've got obviously a very high rate of retail cases across the country. Now, there are some focal points. Obviously, Delaware is a place where a lot of these cases are filed. Eastern District of Virginia, for some historical, sort of idiosyncratic reasons, is a place where people choose to file retail cases as well. The interesting thing about retail, and as we noted in the materials, is that the way they're financed and the way the code changes were put into place in 2005, which aren't really that long ago now. But the addition of 503B9, some additional reclamation provisions, and the way that the lease rejection deadline, or lease assumption deadline, more accurately, has come up under 365D4, all put pressure on the retail debtor that we didn't see before. I've been involved in a number of retail cases pre-BAPSIPA amendments, and one of the tactics or strategies was to build up your inventory before you file and actually buy more goods, buy all the goods you can. Now that had two effects. It created larger unsecured creditor pool, and you could negotiate with your creditors because often they were extended and were owed money, and so you had some leverage essentially over your creditors. Two, to the extent you had an asset-based loan, and the formula included inventory, you actually have financed yourself a little bit and created more liquidity through doing that technique. Now the 503B9 dynamic really makes that a little bit different. It makes it a more difficult challenge as to when and what your inventory level should be at the time. And what used to be the case, which was you would file after Christmas. And so you would see a group of filings in January, February of the following year, depending on how good the Christmas season went for that particular retailer. Now you see them filed all over the place in terms of timing. And so the game is a little different, I think, these days. And
Well, and the whole lease situation, I mean, as you
Yep.
said, it used to be you would file and then sort of take an assessment of which locations you want to keep, because you had time for assumption or rejection of the lease, and you could get that extended. And now, at least what I have seen, is people try to renegotiate the leases before they go in, so they already know where they're going, because they don't have time once they file to do any of that.
Well, Judge, that's exactly right. I mean, this is, again, a vestige of some of the maybe excesses of the 90s and the early O's, where I think Service Merchandise had, I think it was almost 6 years of extensions of the time to consumer reject. And people were upset about that because it locks up your real estate. And so you're correct. Now you go in, I wouldn't call it a pre-pack, but certainly you have groups of stores, a lot of it done, or at least identified, so that you've got to, because you've got to move quickly, or you've got to pay ransom to get that, obviously the extension landlord by landlord. Now, the interesting issue here in this broader macro sense, though, is a lot of these landlords are now themselves under pressure. In the big, the power centers and some of these, the traditional malls, certainly the C's and below malls, as well as the the strip centers and the power centers, are facing a number of dark stores, and as a result,
Well,
they
how
are
many
under
people
pressure.
here are Amazon Prime members? You know, how many people have not been in a mall this Christmas season?
It's the
That's
exact same people.
It's exactly. So, how big a driver is that? And is there, the bankruptcy code can't deal with that, right?
They really can. I mean, what I think it does is it's going to force a liquidation, and you won't see these retailers anymore, other than some of the prime real estate spaces. So the Phipps or Lennox maybe survives, but then there's certainly, they have turned some of the malls and the exurbs into go-kart tracks, into medium security prisons or something crazy like that. all sorts of stuff, churches, whatever happens. You're right. There's a couple of churches in Atlanta that used to be large retail centers, as I think about it. So I guess the point with retail is I think we're going to see the cases are going to be quicker, and they obviously have been, and there's just less liquidity available, and so you're going to see, I think, liquidations in most cases. You'll have some litigation. Sears is a little bit, I think, different because of the way that Lampert ran the company before, and clearly the armies are lining up for that litigation, and so that one will be a little bit different in terms of how it comes out, because I think litigation against Lampert and his hedge fund and some of the affiliates will be part of the story that will be told. One note that we had here, which is the last bullet point, and this is it sort of flows into Congress, but I do want to mention this. There has been, and I think that some of the funds in Toys R Us have agreed to pay at least some form of severance or something for the employees, and so there is a political overlay. I think one at least of the potential candidates has raised this as an issue for 2020. I know there are about 30 or 40 of them now, apparently. But one of them has raised this as an issue, and she's a former bankruptcy professor, and so I think knows of what she speaks. And it's an interesting dynamic in terms of how the hedge funds and the other non-traditional lenders, who are the lenders to this industry by and large, have gotten involved. And what pressures are being applied. The other interesting dynamic, though, and we talked about it in preparation, there are a couple of states that have this kind of legislation in place, and certainly I've been involved in liquidations in Europe or bankruptcy situations in Europe where they very definitely have priorities even over secured creditors for employee-related benefits, at least to some extent. And that creates a consequence because, again, your liquidity, if you're an asset-based lender, you're looking at that and saying, well, I've got to pay for that. I have to recognize that in terms of my liquidation analysis. And as a result, I'm less likely to fund for critical liquidity pre-bankruptcy, knowing that I'm going to have to pay this. And as a result, it really does limit the option of the company as it heads for insolvency or potential insolvency.
So no answers, just problems.
It's the old Chinese saying, we live in interesting times. I think retail debtors are in interesting times. Obviously, we're in a shift. I just think most of these will not survive. You do have a handful. We talked about the situation that was American Apparel that came out, but you really...
The first time.
Yeah, the first time. Well, that's a fair point. And often, and we all know Chapter 22, the solution that is favored and that is negotiated may not be sufficient, and that happens a lot. And so you end up with a second bankruptcy, which often is the liquidation. TWA, I think, went through 3 times and finally liquidated, but that's sort of the one I'm most familiar with. Turning to trade wars and tariffs, this is an interesting issue, and I don't know if you got we've got the slides up. This is, folks in business do not like uncertainty, and this is probably the poster child for uncertainty as to what's going to happen and why and what the political dynamics are and the ability of Congress to interfere with the executive or to have some impact on the executive's imposition of tariffs and how all this hashes out. Those are all unknown questions. I think a lot of people in D.C. are trying to figure out where we're going to end up on some of these tariff issues. Some folks would argue that the president's trying to change the negotiating dynamic with China, obviously. Whether that works through the imposition of tariffs is a very open question. I think that we'll see in 20 years of maybe how that goes and how the Chinese economy changes because...
Well, and you got GM, which of course closed several plants and in the position of having to lay off a number of workers, and they said they lost, what, $1 billion as a result of the tariffs. Now, they're not going into bankruptcy again yet, but, they're not the only ones that's affected.
Did I hear yet? Well, hopefully GM won't. I mean, well, that's an interesting question that came from GM. I mean, GM solved many of its problems, but the fundamental structure of GM was not changed in terms of people characterize GM as an insurance company that happened to make cars because a lot of its operating expenses were retirement payments and health care payments for the retired employees. And I think at one point it was more than 500,000 retirees to about 100,000 or so operating employees. That was the ratio. I suspect that is probably at least that.
But they did restructure the retirement benefits and gave the, whatever the VSOP, whatever it was called, equity in the company,
right.
Blah, blah, blah. But,
we'll see.
No, but that's an indication that the steel and aluminum tariffs can impact a lot of the industries that use those things.
Well, it's interesting. I've got the Wall Street Journal. I bought 2 of them for the last couple of days, and this is from last Thursday, where the tariffs on steel hardly dent imports is the headline. And so the way the tariffs have been structured and whether or not they're really having an impact, some people say we're buying more from China right now because they're anticipating more tariffs and they're loading up their inventory at the cheaper cost right now. And so it's having this counterintuitive effect of actually increasing the trade deficit right now. And so you have that, how this all hashes out is an interesting one. As a business person, you're focusing on what is my cost structure going to be, and I can't tell you what it's going to be. And that's a hard thing. One thing that we have noted, that we have seen is some agricultural bankruptcies, I'll call them, and soybeans is the headline there. And you see, we were reading some stats as we prepared for the panel today that, in fact, I guess it's the upper Midwest, which would be the soybean area, has seen a very significant uptick in Chapter 12s in the last couple of months because the Chinese are buying less in the way of soybeans. Now, there was a significant purchase the other day, but relative to the run rate that they had been buying, it was still pretty low. So I don't think, end of the story there has not been told. Now, can they survive long enough because their demand is still there, and one of the other sources, you have these macro issues here. Where we end up is going to be an interesting question, so I don't know. The sense I would have here is it will be isolated in certain industries and maybe even subsets of industries where the tariffs really staying. GM, I may be using that as an excuse. I don't know the answer to that question. It's an interesting one.
I'll say OEMs that are buying aluminum and steel, they've noticed it, particularly if they are buying components here to comply with these requirements that they have, foreign, the president likes to talk about Mercedes, for example, but they build the vast majority of their cars in the United States, and so they're buying these components. It's not necessarily the divisions that are building them, but a lot of the vendors that are providing the parts. Those costs have gone way up, and those companies are indicating that they're not going to make it that much longer. And so if the manufacturers have to look for other components for the parts, that's when it starts filtering up to the OEMs.
And that's a really interesting question, because the way those relationships, and I really did not apprehend that until we were involved for some parts manufacturers, Tier 1, when GM and Chrysler went down in 2009. I did not understand the one-sided relationship between GM, Chrysler, Ford, and its suppliers, and how the suppliers were essentially financing those companies in large part. And so when the perverse effect in some sense was when they went down, the suppliers were having a little trouble, and they had some leverage over GM because they were the sole source of, at one case where it was a headline supplier for the headliners for the cars, for the very popular truck model.
And this is bankruptcy in the headlines, so we need to
Yes, that's the headliner. Well, I didn't even think about that, but the headliner, and bottom line, GM had to blink. And actually GM, just before GM filed bankruptcy, financed this company because they had no other option for one of its more popular truck models. I can't do it was a pickup truck, whatever, not a truck man, so whatever it was, it was. So these dynamics are not yet clear as to how they're going to hash out. That's a really good point. You're going to see that next layer under some pressure because they're absorbing the cost, and GM and Chrysler, and you could argue Walmart's the same way, they foist onto that kind of risk onto its suppliers, onto their suppliers as a part of the negotiation of the supply arrangements. Just keeping up on time.
No, we're fine.
Oh, good.
The two issues I think that we didn't touch are, as these chips do fall, the valuation disputes in bankruptcy may grow even more complicated because as time passes and the markets change, it probably reckons back to the oil and gas questions that courts had to face. And then finally, the cross-border insolvencies, because many of these assets and productions are all over the place. The increase in 15s may follow as well if these cases choose to buy.
Well, as we noted at the outset, healthcare continues to be an active area of distress. We've had cases recently here in the northern and middle districts placed involving some healthcare debtors. And my reaction is the payment mechanisms and the payment system is so divorced from, as well as just complicated, where it's really hard to really understand what your financial situation is. And I was thinking about the case, Your Honor, I had before you as the trustees council, where it was a nursing home and it was financed in a way that focused on early year cash flow because the relationship with the government was such that sort of front-loaded their income, and then it had recoupment or set-offs in the outer years, and people didn't understand it. And so they were able to borrow more than they probably should have if you looked at a 10-year run rate as opposed to a 3-year run rate of cash flows. Well, they had other problems too, but one of the perverse effects was, well, it was fraud. There was other bad action, there's no question. But as people tried to value the assets, there was a real debate about the timing of how the government pays and reimburses and when the bill comes due, because often there are audits and other reviews of the billing over time. And it's in the later years that you see the recoupment or set-offs come in, and so it affects the cash flow, where folks didn't really understand, as we debated with the appraisers and others about the value of the underlying asset, divorced from the fraudster and divorced from some of the craziness that was going on. How you really valued the company, how you valued it. You've got this interesting issue, and it almost flows into the oil and gas point you were making before. with that volatility. This one seems to me to be more discernible in a sense, and should be, because oil markets are going to go, you know, there's a crisis in the Persian Gulf, or you know, all sorts of things can happen that would affect oil prices almost daily and almost minute by minute, that would have a spike in prices that would either turn you from profitable to unprofitable, depending on where you are in the industry. With healthcare, people ought to have a, it seems to be a better apprehension of this. I was sort of surprised about sort of the debate about this reimbursement thing.
Well, you know, we mentioned hospitals, and I know we've had a number of those in Georgia that have been in trouble, some in bankruptcy, some not. And of course, Georgia, as a state that did not expand Medicaid, has left a lot of the rural hospitals with no choice but to serve the people that walk into the emergency room, and there's nothing to pay for. And that is really something that has spiraled.
Well, there's a good, I think that's right, Judge, and we had a situation with a client that closed the hospital in a rural county along the Florida border because there was no, there was nothing
Nobody
they could do.
couldn't pay them.
Correct, and there was no way to sell because of the cost structure. There was just no way to sell the hospital. To try and even go through it a quick 11 and sell it.
That's one of
There
those
were no
unintended
takers.
consequences.
That's
things,
absolutely right.
Also, the
policy.
care patterns, care has gotten better, and this approach of sending people home rather than keeping them in hospital beds for extended periods is just the old model of how the hospitals remain solvent and the long-term care facilities were solvent is just not aligned with the current care practice. And I don't see that as something that's cyclical. I think that's just a change in how the financing needs to work.
Well, and I think that's a really good point, because you're going to see different delivery models, and you're already seeing that really with the outpatient surgery centers and that sort of thing, where you're right, they want to push people out of the hospital as quickly as they possibly can. And you're going to see almost a separation of how people approach the healthcare delivery system. And so some of them will be profitable, and some of them, at least they are for a time, and people think they are in any event. I guess the long story there is that we are going to continue to see these over time, and
Is there an end game, though, for any of these other than sale?
No, I think the answer is no. At least in my experience.
So this is just a subset of 363s?
I've not seen one, I'm thinking about the last few years in which we've been involved that did not involve a sale. I have not done a study, to be candid with you, that sort of validates that, but that's certainly my anecdotal experience is I haven't seen one that isn't a sale structure. And you strip off, or you try and strip off some of the liabilities. You've got the government as the 800-pound gorilla, and you've got this negotiation of recoupment rights. There is this ongoing debate about whether the recoupment can get stripped, and maybe at least somewhat stripped a little bit for a 363 sale. But you're dealing with that same creditor on the other side of the bankruptcy with the successor, and so there's some real debates about that. And the whole issue of can you sell the Medicare number, for example, free and clear? That's a legal issue. We talked about it at SBLI this past spring. That's an ongoing debate. Verity, which is one of the bigger cases that is filed, that our presenter is debtor's counsel in that case. I think they're going to be looking at those kinds of issues. Where that ends up is an open question right now. And this is what we're referring to is you've got the reimbursement numbers, Medicare number in particular, and the government's position is, and it's an interesting, those are one-page contracts. Now there's 10,000 pages of regulations behind them. And the government takes the position that they can. Well, I forgot about that. We're way over magic wand here. At the end of the day, there is a debate about whether you can strip off some of those claims. I think that the government has been fairly successful in avoiding that consequence, but there has not been sort of what I'll call definitive legal decisions on this issue as yet. And so people will debate it and use it as negotiating leverage, I think. But that's because of the way the reimbursement system works, that's really the leverage point, often, especially to your point, in a lot of these situations, because essentially you're required to provide care, that's where from whom you're getting paid or from which you're getting paid. So that's going to be one of the major relationship.
Fantastic. Well, we've reached the end of our first segment, bankruptcy and distressed industries. And so we'd love to open it up for conversation and questions relating to the first three topics we covered, which are retail, tariffs, trade war, and healthcare. So we'd love to hear your thoughts and our questions.
Is anyone awake?
Everyone lingered a little longer.
Okay, well, if not,
Okay.
Dennis, no, I'll do it, because no one else will. Are there any fixes to any of this? In retail, it seems like every turn, Senator Warren, for example, is adding more cost to bankruptcy. Companies aren't surviving today, and everyone says, why? Why are we having all these sales? Is anyone actually trying to fix and save the companies as opposed to imposing more burdens?
Well, let's break that down, David. When you say, is anyone trying to fix it, are you talking about legislation? Or are you talking about hedge fund guys who think they're smarter than everyone else and think they found a way to get something to work?
Well, they have their own fix, no, but
Well, that's what I'm asking.
legislation is the only thing you can do. Can you roll back any of these to make bankruptcy more viable and to help a company survive and retain jobs?
Well, again, I think the ABI Bankruptcy Commission on Chapter 11 did have a number of recommendations that focus on some of these lease problems. But of course,
That came out with a bang.
right, a commission report, with all due respect to Judge Brown, wherever he is just, step one.
Yeah.
That there's some very well thought out recommendations, but how do you get that moved through Congress? And of course, the reason they're in there is that there were large lobbies of the landlords that wanted this stuff. So who knows where they are now? They have empty stores. Maybe they feel a little different.
Well, that's the question. Has anyone kind of revisited with these lobbyists to see, are you better off with this 120, 210-day process for rejection? Are you better off with, like, look at Boys R Us. It's 503B9 killed the case law and the filing of some other issues. But that's a case that's truly administratively insolvent and was operating that way for a number of months. And so,
the other question is the bigger problem related to the demise of brick and mortar stores and that, and how do the bankruptcy code can't solve that. And I know there's studies been done as to, okay, what kind of industries can survive, there are things that people want to touch and feel before they purchase them. But I think as more and more people feel comfortable with doing the online ordering, get it the next day, if you don't like it, ship it back, it's real difficult. So, the law can only do so much, right? I think we have underlying problems that I don't know how we deal with.
Well, we'll talk about the legislation in the Congress session here. It's just hard to find a home, and I think Judge Diehl's right. When the 2005 amendments came up, I think it was the product of a lot of very specialized lobby and interest. Because
every change to the 78 code was a function of
this one
specialized
was sort of an
law.
amalgam of just little bits and pieces, and so 503B9 was interesting in that I don't think people really expected that to be in there, and it somehow got in there. And David, I think that's exactly right. And you see this in other retail cases where it is administratively insolvent. And so as a 503B9 claimant, I have seen the dynamic come up where it's a negotiation to some extent with professionals as well, because you're pari passu with the professional fees in the case.
well, theoretically.
Theoretically, well, and that's one of the relevant points, I agree, where you're handed 20 cents on the dollar for your 503B9 claim, take it or leave it, because if the case converts to 7, you may not see a dime as a 503B9 claimant. And so it can be those are some hard conversations, is the way I would describe them. Those really don't fix the problem, to David's question, but they do provide a way to at least try and get a confirmation on everybody wants to at least confirm the liquidating plan if they can.
Questions in the back?
So, I wonder if anybody's really thinking through or kind of thinking about Amazon Prime growth. Everybody seems to be purchasing on Amazon, which as a result is we're losing as a country the cash economy and we're going to a plastic economy. And as we lecture on care to students about the appropriate use of credit cards, what's
some of these opportunities for consumers to get access to money more quickly and maybe on terms that aren't as great for them. And there is a concern about that leading to this change in practice where people understand money when they're out of money. And to some degree in this day and age, people more understand credit cards and how the fees work and a bit of that. But taking a step further to the Venmos and to these other quick finance transactions, there's a lot of education gap, and I think especially depending upon what segment of the population you're dealing with, both in terms of socioeconomic class and in terms of generation, I think there is a real concern that all these changes in the way money is spent is going to increase the unfamiliarity with the consequences and lead to a change in what financing looks like and what people's debt package looks like as they lead to bankruptcy. So I think it's a very important concern. I mean, do the businesses worry about that? I'm not altogether sure. I'm not sure that that's a concern. But I think it's something that we as people who counsel individuals who are struggling with their finances and who are using these tools, I think it's absolutely an important part of that structure.
What's interesting, we've been talking about fixes. And again, we're back to a legislative or regulatory fix to some extent, which is we now have the credit card industry, obviously they've got significant balances. We're back up with consumer debt. And is there a regulatory or a statutory fix or some ability to change incentives essentially in this construct? Because I think Shana raises a good point about how people spend essentially, which is different than writing a check, very different than writing a check and actually having to balance your checkbook every month. And people still do that. And with the back of the statement and all that, I just don't think that happens much. But it's an interesting question, though. It turns back on what is the regulatory environment and what is the appetite for legislation. And I don't think people have very good insight into either of those questions right now.
Well, the regulatory, you said there was regulatory protection. It's my understanding it's not doing a lot right now in this sector. And so it would be interesting to see as it progresses.
What's an interesting question, though, because these are alternate financing vehicles. It's not the bank relationship anymore. In fact, the bank has very little to do with this other than a processing system. The traditional banks. And so using the FDIC or classic comptroller kind of regulatory regime doesn't really work here at all.
Well, agencies are trying. They're doing everything they can to reclassify and pull these other vehicles into their jurisdictions because it's very concerned. It's a lot of uncertainty right now. All right, well, we will hold future questions. We're going to have some time at the end for anyone that didn't get answered. But for now, I think we should move on. So our next section, bankruptcy and social movements. There are three primary sections that we're going to discuss here. First, scandal, abuse, and Me Too. Second is student loan crisis. And then third, data privacy. Each of these were big newsmakers this year, and each have a bankruptcy hook that we're going to alternate and discuss with you all.
Well, happy to jump in. I'm not sure I got this topic, but scandal, abuse, and Me Too. I'll disclaim all liability at the outset. This is an interesting question. There are multiple issues here, and obviously we had on the slide at the Weinstein Company, and that is a tale I read yesterday where Harvey now says he's got indisputable evidence that everyone who's been claimed is a liar, and there's crazy stuff going on in the litigation, where it's having an effect, and we were talking about this a little bit at the cocktail party last night, is entities, not companies, but entities are filing bankruptcy to collectivize the litigation. So this is akin to a mass tort situation in the sense of you've got multiple claims and there is an insurance pot available potentially, not in every case, but potentially, that you've got to deal with. And one of the ways you use bankruptcy is to monetize, if you will, or utilize that insurance asset in the best way possible, and that may be the only asset available. Some of these are...
These are the Catholic Church.
Well, exactly, Catholic Church. You've got, again, the Wall Street Journal, they've been talking about the Boy Scouts of America, so I'm thinking about filing Chapter 11. You have USA Gymnastics, and again, from the Wall Street Journal last week, this guy, Nasser, whatever his name is, well, I'll stop there. You've got 501c3 entities that may have precious little in the way of assets and rely on either contractual relationships or donations, which will obviously dry up in this context. So how do you deal with that issue? And so one of the, I think, aspects of bankruptcy that can be utilized effectively and create some value is, as we note in the bullet points, to try and figure out a settlement construct or some mechanism for adjudication of the claims and offer people alternatives. And this happens in, certainly asbestos is one that's tried and true now for, that's 25 years, it's
It has the, release the specific
Yep.
release provisions in the bankruptcy code that none of these other situations have. So that puts you back into this whole question of, can you get third parties released in the context of a bankruptcy plan outside of the asbestos context?
Well, and then there is a debate about that. I think there are some cases that support a 105 release, and then
Right.
back to John's Manville, which was the early 80s, which was sort of the template for 524G.
Depends on your circuit.
It does depend, absolutely, Your Honor. It depends on the circuit, depends on the nature of the claim, because these asbestos is sort of idiosyncratic in a way, because you might have but one fiber, and you might have 30 years in between, and you don't know who actually was involved in the placing the asbestos or responsible for the supplying of the asbestos. This, you do have more of a nexus, and we get into the sort of futures claim issues, sort of the Piper case, and what are, these folks were impacted. On the other hand, they may or may not bring a claim for a lot of different reasons for decades, and how you deal with that sort of lag. I think that's different than the latency issue that you might see as a matter of, is this a claim or not? So it's a metaphysical question of, does this person hold a claim? We're getting a little bit in the weeds, but bottom line, I think the bankruptcy mechanism can be utilized to try and deal with these claims in a way that offers some compensation. I don't see, the USA Gymnastics is a good example. I don't see that entity really surviving. And I think what happens, a new entity driven by people involved in the sport, essentially, to try and take its place, but this entity does not survive, and it really is down to a claim resolution and utilizing the insurance to the extent there is insurance, and then maybe some claims against third parties. Michigan State may have some exposure because of the nature of the relationship. You see some investigations that may have an impact. And they may bargain for, try and get a release, and use 105. And we'll see how that goes. They found in Indiana, which is the 7th Circuit, on top of my head, I don't remember the rule on 105 in this context. So you've got that as a mechanism to try and deal with these issues. The broader societal point, I'm not sure we can answer as we sit here today. As a bankruptcy lawyer, there's always the bankruptcy code. What can I do to try and solve the problem? I think these mass tort cases will be utilized in a way to affect some ability for people to get some compensation. The dioceses, I don't say that very well, dioceses, thank you, I'm raised Catholic. Those are really interesting because often they may not be incorporated, or they may be, there may be a corporation, but then who holds title to the physical assets is a huge issue, and you just don't know what property state is. And so,
But that's why they end up mediating and settling.
yes.
Because those are hard issues, and you've got to give money to the victims.
Well, and you do have, I'll call it the optics, maybe not the politics overlay, but the optics overlay and what's going on in Rome and how that all interacts with what's happening here. That cries out for settlement. And so a bankruptcy at least affords you the ability to have that conversation, and as we all know, that's the bankruptcy 101 is to try and work something out, and so that would be the expectation.
And also, one more thing, bankruptcy is not really designed to solve another mechanism that a lot of these cases have, which is the day in court, the open area, all of this truth-seeking viewpoint that a lot of these claimants have in these social cases. That bankruptcy isn't designed necessarily to do that, but I think courts are, you see in how committees are formed and how special committees and how hearings are held. I think courts are mindful that there's something different about raising these claims, and that there is inherent value in treating them slightly differently than other.
Well, and everybody recognizes that whatever the recovery available is limited, and the longer you litigate, the less there is to compensate for the actual damage, which is true in a lot of why people go into bankruptcy, right? Let's stop that and try to solve it.
Yep. Well, and ultimately, I think you're right. There are mechanisms to try to deal with that sort of erring aspect to it, and people obviously can opt out if they want to opt out of the settlement fund. And I don't think the requiring people to stay in that settlement track is, you're not going to be able to sell that, I think, in most cases. And so if you want to go litigate, they can go litigate. The consequence may be not even sharing in the limited fund that might be available, and they have to think about whether they have third-party claims or something like that that might get them recovery, or whether it really is just simply to expose the issue.
Absolutely. We'll move on. No solutions there. Maybe
Okay,
different-
and I was assigned to talk about the student loan things, and of course, Judge Brown in the panel yesterday, for those of you that were here, where he was talking about the ABI Commission on the consumer law, spent a lot of time talking about student loan, but if you, just the numbers are huge. You know, there's $1.5 trillion of student loans out there for 44 million people. That's a lot of problems. And for those of you that deal in the consumer world, you know that to discharge a student loan in the bankruptcy context is very difficult. 523A8 says you've got to have undue hardship. We are burdened in the 11th Circuit with the Bruner test, which came out of the Second Circuit at a time when the statute provided that you could not discharge a student loan within the first 5 years after you graduated. And so there may have been some sense at that point having a standard saying you had to have a certainty of hopelessness, meaning, okay, you just got out of college, make sure, let us know that this is going to really continue for this period of time. The statute then went to 7 years and then ultimately applies to all student loans. Then was expanded. Originally it was just the publicly government-funded loans. Now it's also private loans. So you really have a huge mess out there that you've got to deal with. And you know, as Judge Brown said yesterday, there aren't really any good solutions right now within the bankruptcy code. There have been at least 10 bills introduced in the House and Senate to try to get at this problem, everything from actually rolling it back to the way it used to be, apply it only to public funds, put some time limits on it, others seeking to avoid people taking out more student loans to begin with in terms of counseling requirements, etc. But you know, none of that, at least at the moment, is going anywhere. So I thought I would just take, because Judge Brown did cover so much of the whole crisis, I thought I'd just take a few minutes. If you are a debtor's lawyer and somebody's coming into you with a student loan, you can of course hear all the facts and make a decision as to whether or not there's any chance that you could win under 523A8. But if not, there are a lot of repayment plans out there available, and you need to make sure that your clients investigate all these. You know, the standard student loan is payable over 10 years in equal installments, and depending on when it's public or private, the interest rate varies, how much of a grace period you get varies, but basically you get 10 years to pay it. If you can't do it in 10 years, there's a number of other options. You can get a graduated payment scheme so that, you know, when you're right out of college, you're probably not earning as much as you might be earning 5 or 10 years down the road. So you can get a system that lets you graduate the payments, and they're lower and then they increase. And again, that's still over that same 10-year period. You can extend that graduated thing up to 25 years. Not that your client necessarily wants to do these things, but if they're not going to be able to discharge it, these are options that are out there. There are also pay-as-you-earn and income-based repayment plans where they look at what your disposable income is and then have a payment that is 10% or 20% of the disposable income. You do that for 20 years and the rest of the loan gets forgiven. I have seen cases in court where that income-based repayment plan results in a zero payment for the debtor for that 20-year period. I mean, it obviously has to be redone. I mean, the problem with all of these loan forgiveness things is forgiveness of indebtedness income is a result. So you get the loan forgiven and you get a tax bill. And so that's a different aspect, and there are some bills trying to solve that. But I think it's important, if you have a debtor, to investigate what the options are with them, because bankruptcy is probably not going to be your fix in 90% of the cases that you've got. And you know, something's got to be done about it. And maybe the ABI Commission will have good answers.
Well, it's interesting, as I listen, Your Honor, we're back to a legislative fix, because this is, went back to Congress, and it has been now since 2005, we have major amendments that were sort of due for some, and some argue for really due for an entire renovation of the 78 code. This is a problem that is to some extent the government's own making, because it's an active player, obviously, in this market, if you will, and has been pushing a lot of money out there that has the consequence of raising academic costs or educational costs. Where I don't see anything happening between now and 2020.
Well, you know, and we had, you know, for a while, we had a group of the for-profit schools that a lot of the money had been poured into, and there were some policies about loan forgiveness for those. You know, the current education department has cut back on a lot of that. You know, that's a whole separate set of issues. I mean, I had a case involving a helicopter school where the students had borrowed the full tuition, paid it up front. The school closed halfway through the program, so they got no benefit out of this whatsoever. And yet, when you applied the Bruder test, it was an educational benefit loan. And no, these people weren't qualified to fly helicopters, but they had other skills, so you had to look at what could they do. But that's like crazy.
Well, had the debt been sold, where the creditor had been asserting itself as a holder in due course, if you will, and by that I mean, I assume some fraud was raised or something was raised as a defense of the obligation. Because you do have, for-profits have some, at least some aspects of that have been raised as to whether or not they fairly treated their customers, if you will, the students.
Well, and, you know, some of these loans are parent plus loans, so you have parents who have borrowed the money to send their children to school. So then you have debtors who are, you know, in their 50s or 60s who have hundreds or tens of thousands of dollars worth of debt, which even though they got no benefit out of it, it doesn't really matter. You don't have to get a benefit out of this.
Has anyone tried to, I mean, I know that people are suing on fraudulent transfer theory with respect to payments.
That's payments they actually made. These are loans they undertook.
But 548 applies to obligations. And so why wouldn't you take the position if this was a constructively fraudulent obligation incurred by the parent? Then you ought to be able to avoid it as a constructively fraudulent obligation. They got no benefit, and they incurred $100,000 of
Interesting.
debt.
I haven't seen that tried.
I think that ought to be tried.
Yeah, but they're probably not insolvent because we got a house that's probably paid
Well,
down.
but if the total, the 100,000 is on top, it really depends.
It depends at the time that they incurred the obligation.
That's a fair point. I'm not sure.
But they're in bankruptcy now, so they've got a problem.
Well, it's cash flow problem for them though, it's not.
It may not be an, you know, you would have to prove insolvency on a constructive fraud theory. I decided not to go to the actual fraud argument, which is they were defrauded along with their student, their child student, in terms of what they were buying with some of these for-profits. I think there is some evidence, it seems to me, anecdotal it may be, that these really aren't on the up and up. And so I would.
But most of these are not the, you know, the for-profit schools. A lot of these are, you know, look at those student loan cases. You're talking about, you know, Seven Sisters, Ivy League
Well,
schools.
you were talking about that, Judge, before we started. Yale undergrad and Georgetown Law, I think, in one case. That was perfumed.
The problem that I see more often is somebody having $150,000 for an adult literacy degree. That you can, you know, the most you're ever going to make in your life on that is $35,000. I mean, it's economic.
Crazy.
Well, or ancient Sanskrit or French literature or something like that.
Yeah,
I mean, in terms of the majors. Yeah.
Law school.
Judge.
Is it your undergrad in music?
Yeah. Music.
Was
Okay.
Gene Weedoff's undergrad. Look, you know, he made something of it.
Yeah. Well, that's a harder question, I guess. I'm surprised that no one's tried the fraudulent transfer theory or fraudulent obligation theory, because it applies, 548 applies to an obligation fraudulently incurred, or how you want to put it, in a constructive fraud case, a voidable transfer, if you will, and maybe that you might be able to sell that.
Okay. Take it
So
out.
much we know that. All right, I'm going to speak about data privacy now. So data privacy it's just increasingly in the news as everybody in this country and everybody around the world creates more and more data on a daily basis than, you know, people 10 years ago, 20, even 5 years ago. And so the way companies collect this data and share this data and sell this data and lose this data all of it is something that's very concerning to both businesses and individuals in their lives. How does this actually interact with the bankruptcy code? Well, in a number of ways. First, as I said, not only is there sensitivity to how data is treated, this impacts businesses as they're having to prove to customers that they're taking adequate protections to guard this data, to not sell it, and I'll get in a minute why those policies that are consumer friendly actually can impact the bankruptcy treatment in those countries. I'll also say that the regulatory regime is changing very quickly. So there's GDPR, which is the EU privacy standard, there's state data protecting statutes, there's all sorts of response to this general sentiment about how data is treated that is, it's increasing costs on companies, and it also creates a more challenging web for for businesses going through bankruptcy. So on top of that, there are a number of high-profile data breaches. Just as there's more data, there are more people willing to take advantage of it. We see in the headlines this year the Cambridge Analytica case, very high-profile data breach combined with some other problems, obviously, leads to bankruptcy. And as we were talking about in the social movements, how bankruptcy is, in many cases, by default, the tool that is the environment in which these problems have to be resolved because the companies file and the courts really don't have a choice. Courts are dealing with what happens when these companies have completely failed everyone, and then you have countless people who are harmed. How do you go about dealing with that? Again, as I said, the bankruptcy is an option for companies facing breach liability, and the voice and the role that consumers have in this process. So, for example, in the Cambridge Analytica bankruptcy, there is a constituency of data breach claimants, and it's still ongoing. There's no hot take yet. I was hoping there would be a headline before today, but unfortunately, we're not quite there. So that'll be a New Year headline. It remains to be seen what actually will happen and what data these claimants are able to get through the bankruptcy discovery process. Another overarching shift that I think will lead to more future bankruptcies and already has, cloud-based business solutions are just incredibly popular right now. If you speak with in-house counsel, you mention cloud deals, they just get they get this look in their eyes because companies are moving so quickly to move everything to cloud-based solutions. Oftentimes, these deals are made with startup companies that haven't, maybe have good policies, but maybe don't have the funding or the backing or the experience to protect this data. So I've seen a number of cases where these startup companies have all the company's data, and then they file for bankruptcy because any number of things happen. The backers pull the money, the regulators sweep in, any number of things can go wrong, and so then you have a company who all their data is in a cloud provider that is in bankruptcy. They're concerned about, first of all, they should be concerned about whether the business can even operate, whether the company will be able to keep going in bankruptcy and will be able to provide those services. The Tintry case, which is one of the graphics we showed, luckily that company came in and bought them and kept them going, so the company still received their cloud-based services. But there's a real business interruption that happens in that case. And then the next option is what happens with this data, both consumer data and business data, when these companies are in bankruptcy. So the last point, the BAP-CPA amendments in particular made changes to how PII, personally identifiable information, is treated under the code.
We have our consumer privacy ombudsman, right?
Exactly. So there's the protection of the ombudsman, and I think more eyes on the problem I don't see as ever a bad thing. I think at minimum it provides another layer of review, and then the other hook of that change is that the companies in bankruptcy have to comply with their privacy policies. So we saw in the Radio Shack case the fact that consumers were told in the storefront that their data would not be sold and be protected, that they were bound in bankruptcy to not share that data. So consumer data lists can be incredibly valuable in bankruptcies. Oftentimes it will be the most valuable asset of a company that goes. But as I said earlier, the more protections that are provided to consumers, and as society shifts, they're being demanded more and more, and so more companies are providing these things, it is inversely related to what actually is valuable in bankruptcy, because if these protections are in place, companies are going to be able to sell them so freely, they'll have to be so heavily redacted and stripped that the value is just much, much lower. So again, one of those issues that continues to evolve, the regulations haven't fully caught up. The code has, in some ways adapted, but I think we'll see future shifts as more of these companies that are responsible for all of this data are turning to bankruptcy to resolve the issues.
It's an interesting investment banking problem, which is how do you value these companies and what are they worth? And you bring an investment banker in, I think the model of sort of cash flow is completely irrelevant to the conversation. So to your point about what is the value of the data and what are those contractual relationships, it comes back to what are the contracts with the ultimate consumers or with their counterparties who then interface with the consumers. And what do they do with data? Because these contracts are often negotiated between sort of the IP lawyers and the IP professionals without much regard for what would be the consequence of this context, and may not really address this kind of issue at all, or give all the rights to the provider and none of the rights to the customer. And I think that's probably pretty common, and that's one
Well,
of the
don't
debates.
you get all these privacy policies in the mail like every day?
Yeah,
Do you read any of them?
No. The same with,
So,
people
nobody-
who agree. I mean, and that's the guy who, I was watching the 60 Minutes news report on the guy from the European Union, who's a young lawyer pushing on this issue, on the privacy issue, which is these are contracts of adhesion. And when's the last time we talked about that? That was sort of a 70s kind of era thing that's sort of coming back now. Everything old is new again, because the relationship between these providers and consumers is essentially unequal, and the bargaining power, you can't really look at it in a true contract-based approach. We'll see if the courts adopt any of that anytime soon with the regulator. Obviously, the EU has a more robust regulatory approach to this. But it just struck me, you've got sort of an interesting bankruptcy problem, which is how do you value a company that its only asset may be the data that it has, and you've got to keep the power on the servers. It doesn't really have anything else. It's tables and chairs, and the employees have all left. So how do you deal with that situation? I don't know the answer right now.
Appoint a trustee and let him or her worry about it.
Well, there you go. Now what do? They try to sell the data.
Right.
And maybe they can, maybe they can't. And the ombudsman is just simply another cost to the Chapter 11 administrative expenses that the estate can't afford, potentially.
All right, so we will take a minute. If anyone has any questions that they'd like to raise related to the social movements topic. Again, we discussed scandal, abuse, Me Too, the student loan crisis, and then also data privacy.
Questions, comments?
Thanks.
Okay.
All right, well then I think we'll move on. Here we have bankruptcy in Congress and the terms of Grace Diehl.
Okay, so we're going to talk really, I think the slideshow has two things, but I'm going to talk about a newer bill that's also, but I'm going to start with venue reform. Senate Bill 2282 has been introduced in the Senate with bipartisan sponsors, Senators Cornyn and Senator Warren. And what it would do is curtail the currently available venue options for corporate debtors. So currently we have 28 U.S.C. 1408, which is a unified statute with respect to venue for both individuals and corporations. And it allows any of those to file where their domicile is, their principal place of business, their principal assets, or where there's a case pending involving an affiliate of the debtor. So that's a pretty broad choice, and of course to the driver behind this bill, it has led to there being what they call magnet courts in Delaware and the Southern District of New York, and a couple others more recently. And so the view is that this is abusive, that companies ought to file where they're really located, where their principal place of business or principal assets. So I thought it's interesting to kind of look at how we got to where we are. In the 1898 Bankruptcy Act, domicile was an available option for everybody, but it was not really defined, and it was never really something that any court looked at. Then in 1934, Congress added a venue provision that said in corporate reorganizations, you had to go where your principal place of business or your principal assets were. So it was narrowing the choice at that point. Then in 1938, we get the Chandler Act, which has both Chapter 10, Chapter X, and Chapter XI. And in Chapter X, which was for public companies and dealing with secured debt, your only venue choices were principal place of business or principal assets. And of course, the individuals through all this always could file where their domicile was. Chapter 11 also allowed you to file in your domicile or your state of incorporation, but remember, Chapter XI couldn't deal with secured debt, and it wasn't for public companies, so it was a subset. Then, in 1973, we get Bankruptcy Rule 116A1 and A2, which separated the venue provisions for individuals and for corporations. And so individuals could file domicile, principal place of business, principal assets. Corporations only had principal place of business and principal assets. So that's where we are in 1973. And then we get the Bankruptcy Code of 1978. And it collapsed the two venue provisions. So we no longer had separate individual and corporate provisions. So we only have one. That was in 1472, and it's substantially where we are now. The 1984 amendments they changed the statute. It's now 1408 versus 1472, but they were substantially the same. So we have a history where there were more restrictive venue choices for corporations at various points in time. I think it's also interesting to contrast the general venue statute for district courts as to where a corporation, as a plaintiff, can bring a case. And in a corporate plaintiff, it can only have its residence, which is the term used in the statute, where it maintains its principal place of business. So in a district court, which of course the bankruptcy courts are units of, the definition is much more restrictive than this. So against that background, we now have, as I said, this multi-choice of possible venues. And what the Bankruptcy Venue Reform Act of 2018 provides is that it removes domicile as a venue choice for non-individual debtors. And of course, almost all the cases filed in Delaware filed there because they are incorporated in Delaware, which is their domicile. There are not very many companies that have their principal place of business or principal assets in Delaware. So it's really sort of aimed more specifically at that, I think, than even the Southern District of New York, which has venue for a number of different reasons. So it removes domicile, and the other thing is it limits affiliate venue to affiliates and to an affiliate that's owned 50% or more by an already filed debtor. So in other words, you've got to have a parent. If a parent goes in, any subsidiary that they own more than 50% of can latch on to that filing. And of course, if you look at how people got where they are, there's a number of cases that have gotten where they are by using this affiliate status of a teeny tiny affiliate that they then lump on. The most famous is probably Eastern Airlines that filed the Ionosphere Club in the Southern District of New York and then filed Eastern to lop onto that. The other thing that the statute does is it mandates that the court transfer venue if the case is inappropriately venued to be filed with. Now, how you enforce that, we have a few Rome lawyers here, but we know that in the Northern District of Georgia, which appends the Eastern District of Tennessee, a lot of Georgia residents file in Tennessee for a variety of reasons, but probably going to not have Judge Bonfeld, but we won't go into that. No, seriously, they say that it's so much easier.
Things are loose by the loose.
It's easier to get to Chattanooga. There's some things they do in connection with their Chapter 13s that are, less burdensome, whatever. But if you have this statute, you may have it, if you had this statute, that would say to the Tennessee court, if you get a petition that's from a Georgia resident, you must transfer it to the appropriate division. So they're looking for co-sponsors in the House. It's obviously not getting passed in any lame duck section, but I assume that it will be reintroduced next year. I think the whole venue issue is a very hot and divisive topic because there's an awful lot of people that are invested in the current system, the way it works right now. Dennis, in fact, told me it ain't broke, don't fix it. there are a number of districts led, I think, by, well, there's a number of districts over the years that have adopted complex case procedures. Northern District of Texas was one of the first to do that. The more recent, pardon me? The more recent iteration of that is something that was done in the Southern District of Texas, which is to limit the judges who receive complex Chapter 11 cases. Our own Northern District of Georgia is working on a procedure of that venue. The idea being, and I was on a panel at ABI Southeast this summer, and we had Delaware and big case lawyers who say that if you have a district with a lot of judges, it's just too much to do due diligence on. You need to have just a few. I mean, the Eastern District of Virginia, which Dennis indicated has gotten, they had Circuit City, they've got Toys R Us.
Exactly.
They have only 2 judges. They happen to be 2 judges who used to be law partners of each other that think and act alike to a large degree. So that's something that has more certainty to it, if you will.
Predictability might
right.
be the way to
Yeah.
express it. And certainly, people express that concern. And it may not just be the Lynn LaPucky's case placers, and then Professor LaPucky, has a particular agenda or particular approach to this issue.
His theory is that judges market to get these cases by, awarding the fees without looking at them, doing whatever the major players need done so that they get more cases, and
There's an ongoing debate. I mean, this is not a new issue, obviously, folks. It's in the headlines because it's now legislation. We have a different Congress, we have a different administration, obviously, and different pressure points, and another few years of history on all this because...
But we still have a Delaware senator on the Senate Judiciary Committee. So.
Yes, he will do what he needs to do, I think. But it's an interesting, predictability is one way I've heard it expressed as a concern by not just the lawyers who might be counsel for the debtor, case placers, as it's called, but also the
they're case placers too.
They absolutely have a lot of leverage when you have a conversation as things get tight as to where they'd like to see things filed. And have the
But
ability.
that's what the statute is saying. Why do we let people forum shop to a district that has no real relationship? Yes, their papers of incorporation are filed, but there's no employees there, there's no operations, there's no headquarters. Why do we let that happen? I mean, I'm just arguing it, not
Understood.
telling you.
And that's
So,
that's the
no other litigation do you get that kind of choice. If you're a plaintiff in district court and you're seeking to rely on diversity,
yeah.
And you have a defendant that's present, you can't go to some other place and file it just because you want
Like the
to.
court creates diversity in that
Yeah.
sense.
Well, but in other collective litigation contexts, there is some degree of this as well. Right? There are districts that are known for maybe not getting class action dockets. I mean, there are other examples. I agree.
IP cases, yeah.
Bankruptcy is special in that way, but I don't think it's alone.
But anyway, so that's out there, and if you have an opinion on it, write your congresspeople. Okay, fee increases. This is really just, there is bills in both the House and the Senate on Chapter 7 trustee compensation. I think this was alluded to a little bit in Judge Brown's yesterday. But 7 trustees now basically have 2 sources of their compensation. They get $60 from the filing fee, and it was pointed out yesterday, if there's a fee waiver, they get nothing. And then in addition to that, they get a percentage of the assets. The statute says monies dispersed or turned over by the trustee to any party in interest, and it's a graduated scale. What House Bill 3553 makes 2 changes. It increases the fee from $60 to $120, and it was last set at $60 in 1995. So, I think there is uniform agreement that it is way out of sync with where we need to be. And second, what it does, it indexes that $120 to the cost of living increases. There's all these provisions in the bankruptcy code that are re-indexed every 3 years. Chapter 13 debt limits, all that kind of stuff. And this would put this in there so that we wouldn't go for that long a period of time. I think there's substantial consensus that this is all a good idea. The problem being, how does it get paid for? You know, I think there's no real debtors lobby in Congress, but I think there is a feeling that we shouldn't put the burden of this on debtors. Debtors already pay $305 to file the, you know, Chapter 7 case. Another $60 on top of that is substantial. How do you get that, you know, can it just come out of the filing fee as it currently is? You know, as I think Judge Brown was saying, we're not quite sure what happens to the rest of those filing fees anyway. I guess they go to the Treasury. But I think this will have some traction. Again, it is not, it's not going to be passed in the lame duck section, but it will be reintroduced. And then the other thing that I'm going to mention that is not on the slides, because it is bills both in the House and the Senate, Senate 3689 and House 7190, that were introduced on November 29th, which is the Small Business Reorganization Act of 2018, introduced by Senator Grassley, who's a Republican from Iowa, and Senator Whitehouse, who's a Democrat from Rhode Island. So it does have, you know, bipartisan support. And the House is actually Doug Collins, who's from northern Georgia, and Tom Marino from Pennsylvania, I believe. So again, we've got bipartisan support in both the House and the Senate. And a lot of what it does is tracks the recommendations that the ABI Chapter 11 Commission made. And you know, I think Senator Grassley being a sponsor, Sam Giordano of ABI was his chief of staff 20 years ago. So I think there's a reason why Senator Grassley is a sponsor. But what this does is, you know, we already have separate small business provisions, and this really reforms those in certain degrees. But the major things that it does is requires the debtor to file the plan within 90 days. I think the current small business gives you 300 days, but then it also, the current requires the court to confirm that plan within 45 days. And that's really kind of unmanageable in the realm of things. So this says you got to get that plan filed within 90, but it doesn't have any strictures on the court in terms of the confirmation process or the time. You can't, and the court can extend the 90 days if they want to. It has certain aspects of 1129 do not apply that would apply in a larger corporate case. It really eliminates those individual debtor provisions so that if you are an individual who is a small business, you can probably much more easily confirm a plan. There is no creditors committee appointed in a small business case, and there's no disclosure statement required. It's a mandatory, you know, the plan has got to provide the information that you would normally find in the disclosure statement. And only the debtor can file a plan. There's no, it's not just exclusivity, that's it. Nobody else can file a plan for a small business. And the idea is to make it much more cost effective, because most of the cases filed, and small business, the definition doesn't change, so it's under about $2.5 million is the current number, maybe up for a revision next year. I can't remember. Next year's one of those times. But and it also, this is something that I skipped over, it requires the court to hold a status conference in the case within 60 days. You know, under 105D now, the court can hold status conferences in any kind of Chapter 11 cases, but this requires that it be done. The idea being, figure out where you're going and let's get this case moving quickly. So again, I think that's, you know, both houses has bipartisan support. I don't really know what the major opposition to something like this would be. I mean, this is sort of grown out of Tom Small's long time ago. Let's do things a little differently.
Yeah, the consolidated planning disclosure statement and other courts have adopted that approach, and I think it does make a lot of sense. Remind me, does it have the absolute priority issue in there or not? We talked about that in preparation.
No, and I think that you pretty much can write that out because, I mean, it doesn't change that provision of 1129, but with respect to an individual, if you make the payments over the 3 maximum 5-year period, so it has some Chapter 12 kind of look to it, you get your discharge and you don't have to pay everybody in full and you can keep everything. So it's more attractive, but you know, my experience in these smaller business cases, it's hard getting creditors interested in the case. You know, so.
Does it have a provision? I've read it, so this is an open-ended question. The U.S. trustee, is it thought that they would be more involved to keep an eye on things, or simply this the 105 conference will serve the purpose of
You know, it's
explaining to the debtor, get it
it's
done.
one of the, when you try to read this bill, it's like, it was difficult for me to follow it all because it starts out by saying sections 105D, 1101, 1104, 1105, 1106, 11, blah, 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 do not apply in a case under this chapter. So then you go back and try to cross all those out. And then coming back in it, it says, oh, but you have to comply with, we've struck the full thing, but now you got to comply with these subsections of it. So it's very difficult. It does apparently have a provision where you can have a standing trustee for small business cases. And if you don't, then the U.S. trustee would appoint one. And the provision for appointment of a trustee is almost like the simpler provision used to be pre-BAPSIPA rather than all this double negative stuff that's in there now. So I think, you know, if the debtor obviously is fraudulent or anything, you can immediately get this standing trustee. And the payments in the plan are made through a trustee, almost like a, like I said, Chapter 12.
Yep.
Like. So it'll be interesting to see where that goes. And that, like I said, that to me is something that might actually happen. So that's bankruptcy in Congress.
I will add one other point
Okay.
about the Chapter 11 increase. As of January 1, I don't know if you'll realize, some cases it doesn't really register, but in a number of cases, the quarterly fees for Chapter 11 businesses the scale has changed, and the result is that a certain subset of cases, they've expanded and increased significantly the cost of being in bankruptcy. The cap was previously $30,000, and now it's based on a percentage, but it can go up to $250,000 per quarter. And that is just really changed the cost of bankruptcy. And so we've talked about factors that have shifted venue and where you file. This is really impacting the timing of filing. Because if you have a runway and you have your financing, you need to speak with your lenders about what the cost of bankruptcy will be, depending upon how long a case may go on. So I would anticipate, I haven't seen data on this yet, that the increased cost for some of these cases will result in a delay of filing and a further narrow the number of cases that are completely prepackaged that are designed to get in and out. Just because, you know, if you're paying $250,000 a quarter, it can really shorten your runway.
Well, that's what, you know, this goes back to the first segment on the retail stuff. I mean, and the whole 363 thing. Now, cases don't last as long as they used to, by and large. I think I read something like 83% of the Chapter 11 cases with confirmed plans are pre-packs, which means they're in and out in, what, 90, 120 days?
Exactly, yeah.
And then of the ones without a plan, they're either conversions or 363s. So, and those happen because the lender, the time requirements of the bankruptcy code, the requirements in the DIP loan to get it done quickly, people aren't hanging around with this kind of, you know, possible disbursements. The cases may hang on with the officers and directors liability litigation, possible preference, but the case is done.
The liquidating trust or whatever the
Yeah.
mechanism might be
Yeah.
will proceed.
Yeah.
Exactly, yes.
All right, so with the time remaining, I want to just touch briefly on a couple emerging technology topics that are absolutely in the headlines and may or may not to date interact with your practice, but certainly will be around in the future. So just three different buckets of things. FinTech, which is financial technology, we touched on briefly earlier. Cryptocurrency and its role in the bankruptcy process. And then finally, artificial intelligence. We'll start with bankruptcy and FinTech. What actually is it? So these companies are companies that provide financial services. It is basically technology that enables consumers and businesses to access and use financial services in different ways. And it's a very broad definition, and so to do a presentation on different types would be incredibly long, but just broadly speaking, it's really just a combination of technology to provide financial services. Now, there's a number of factors that cross with the bankruptcy code. Right now, FinTech companies, many of them are relatively new, a lot of them are startups, and so not unlike the discussion about cloud-based technology, these companies suffer from many of the startup company issues.
So give us some examples. Is this like Equifax? Is Equifax?
I'll dive in and I'll talk about an example I really want to talk about. Upsolve, for those of you who don't know it, this is actually a bankruptcy FinTech startup. So Upsolve is basically the TurboTax of Bankruptcy. It's a nonprofit that was started, it's a couple years old. It's basically you don't have an attorney representation, but it's an app where you can file for Chapter 7. It's only 7, and it's only for very limited groups of people. You can use Upsolve to file for bankruptcy, and
Is the app free?
It is free.
Already,
You have to pay your filing fees. You still have to pay the education fees, all that, but it just takes the lawyer cost. Yeah, I did one this morning. I just kind of mocked it up to see where it was going, and it's new, but it is growing, and I think it's one of those things that people who may not consider bankruptcy, it gives them an option to do so and a vehicle to do it to reduce their costs. So.
Do you agree at the front screen that this is not legal advice?
Absolutely.
It's not anything for you?
Absolutely do.
You're at risk and you understand all
Correct.
the bells and
Correct.
whistles.
I
Okay.
mean, there are problems inherent in a lot of these things, and if you take a lawyer out of the mix, or you take a lending institution out of the mix, some of the problems that we've discussed is that a lot of these companies will say, oh, well, I'm not a lender, so I don't fall under this regulatory scheme. Or, oh, I'm just a technology provider, so even though you're getting a loan through my app, I have no liability. So there's a lot of uncertainty in this sector, and it will continue to develop. I think people in particular, consumers, like being able to do things quickly and on their phone and remote, and not having to go into a bank to get their loan or their money. So keep an eye on this to continue impacting business going forward. And again, Upsolve, really interesting. For those of you that are in consumer cases, if there are consumers that perhaps can't fit within what you need, but they would otherwise be a pro se debtor, it's absolutely worth just exploring.
They're still a pro se debtor.
No, they are. Sorry. Correct.
They're an Upsolve.
They're an Upsolve debtor. Thank you. Let's see. So the cryptocurrency issue, I think a lot of people thought it would go away as a fad, and I think maybe people still think that, but it's becoming more and more mainstream. So courts are having to deal with these issues. Agencies are dealing with these issues. It is here and it is happening. So even if it's not something that you want to be a consumer of, it's very important that you understand what's happening, at least broadly, and how it may impact your practice, because it's not going away very quickly. So really, what is cryptocurrency? Let's just start there. It's decentralized, so it is not backed by a bank. It's anonymous digital currency. It is now used for all sorts of legitimate transactions, whereas people thought of cryptocurrency as in the shadows and not really legitimate. It's out there. You can use it to buy all sorts of things. Lots of companies invest in cryptocurrencies. Lots of them hold it. It is, for better or worse, it's not a normative statement, it is out there that it is a much bigger part of business and individuals' lifestyles. What do we care about? For bankruptcy, it's a really open question on a number of fronts. The first issue is classification. What is cryptocurrency for purposes of the code, and why does that matter? So, first of all, it's important to recognize that cryptocurrency is an asset of the estate. It falls under 541 pretty cleanly. There's not really much dispute about that. But the question is whether it is a commodity. So some courts have held that way, not necessarily at the bankruptcy level, but at the district court level. Think of it an example of avoidance actions. So under Section 550, the trustee can recover the value of the asset at the time of the transfer if it's currency. But if it's a commodity, the change in value will actually inure to the benefit of the trustees. So this debate about correct. I guess that's right. The debate about what actually this is has really important impact on how the bankruptcy process works.
If it's a commodity, does it fall within all the safe harbors? If it's a trading contract, what does all that have on preferences, while transfers?
Well, and it also comes up,
or lack of the need for state-related settlement.
It will come up. It'll come up in 503b9 claims. It'll come up in claim confirmation. This is again more back to the oil and gas point. The volatility in how these are valued can be a real claim confirmation question, because you may have the historical value, but the ups and downs of all of these assets can really vary a lot. The other thing that's not up here is when the estate has these assets that are going to be distributed, there can be a real impact on the valuation just by releasing them into the market. So for example, in the Asst bankruptcy, which is the Bitcoin exchange that was hacked, this was not the United States proceeding, but by releasing all these Bitcoin on the market, it really lowered the price. And so they actually had to take the assets out of bankruptcy and actually just distribute the coins itself to investors rather than monetizing them. So again, If you have a case that involves Bitcoin, you need to spend a lot of time understanding the market, understanding what the asset is and the current scope of the landscape. It's changing very quickly. The SEC is very invested, FTC is very invested. All these agencies are trying to wrap their arms around it, and they're very reactionary. So just to give you a very brief introduction about where it is and where it may be going. And then finally, artificial intelligence. A lot of people laugh when you mention artificial intelligence and the role it may play in the law, but it is playing a role in the law right now.
Yeah, I ask Alexa all the time to tell me the answers.
You get answers?
It is, first of all, in bankruptcy, just a very brief generalization, which you would need to spend more time reviewing, is because the IP rights behind the artificial intelligence software are namely patents and copyrights. The way those IP rights are treated under the bankruptcy code, it seems most likely that courts will group AI software and the licenses that go along with it in the same way. It's currently not well defined, but if you think about the way licenses, the restrictions on transfer, the ability to continue using your rights as a licensee if you're not a debtor, those same doctrines apply in this context. But again, the law may change on that. There are just a lot of these issues haven't been described and addressed by courts. And then finally, in bankruptcy practice, so we have law firms already employing Ross Intelligence, which is the IBM Watson product, in their bankruptcy practice. And so they use the computer for help pulling research together and bringing it to the associates to really eliminate some of the legwork. Also, lenders are using it for the risk of AI to predict the risk of bankruptcy. So they'll run transactions and they'll use the computers to be more predictive about what bankruptcy looks like. And again, I think that it is really possibly that the judiciary may have ultimately adapted. I have a colleague that's doing research on administrative agencies currently using AI for their enforcement mechanisms all throughout the United States. So it is coming. It's just a question of when and how, and just something that's definitely in the headlines and will continue to impact the practice of law and life.
So at a confirmation hearing, you might hear evidence from some algorithm-like person that says, this plan has a 98% chance of success based on...
I wouldn't be shocked if experts coming forward with that sort of evidence are fewer than 5 years away. I think that that will become very valuable when companies will recognize that it's a good way to show whether their plan will be better or not. I imagine people investing heavily in it right now and just haven't brought it to the mainstream.
Well, I guess, the whole discovery predictive coding, when you do, that's all AI, right?
Yes.
I mean, then imagine even in chambers, and not to assume that this would be the way, but if we know based on the jurisdictions that this many cases with these sort of facts came out this way, that would be really valuable information, at least as a front line, to give to the clerks in the court for reviewing how they would approach a case. And that sort of information just takes a ton of man hours to get under the current systems.
Well, so for example, Chapter 13 cases is, are they going to actually be able to make the payments over the plan period? Would you say there's a way to analyze that, say, as a broad measure with these kind of factors? These are more likely than not going to fail. Does that have an impact on how you approach Chapter 13 confirmation, for example? Because each Chapter 11 case is, I would at least argue, at least at the moment, that it's its own case. And you've got to look at the facts, whereas 13s you might look at broader, or be able to look at broader. We've got
Right, is the debt paying now? Okay.
Right, and what's the,
Yeah,
and
but
is there
that's,
any reason to do
for
that?
chapter 11, the reasonableness of projections.
Right.
Right, but it folds into your expert testimony. I assume that
Yeah.
you're still going to have a live person sitting in the stand subject to penalties of perjury and under oath, talking about it and making a professional judgment. We're not simply going to have the computer that might backstop some of the analysis, and then we can argue my algorithm is better than your algorithm on the other side.
Well, it's a Daubert question, right? This
There
is
is.
a generally accepted
Yeah.
algorithm, whatever.
Yeah.
All right, well, thank you so much. We are at the end of our time. We're happy to stay up and take your questions after the panel. Thank you all.